aqui mesmo. Hã?
Começamos agora em um minutinho, tá? Porque todo o pessoal online, a gente tem que... Vai atrasar um pouco, né? Tem vídeo?
Sí, está en vídeo para todos los paneles.
Tá.
Luego comenzamos.
Ok.
É muita coisa para... Eu vi a notícia da Merge, que o André Gustavo tinha visto.
Não, eu pedi para eles colocar o nosso também. Tá?
Não, então, no nosso tava a notícia que ele tinha vindo.
E o Tedesco contou também no site do Instagram, o link deles.
Bom dia.
Good morning. It is great to be here to moderate this panel with two icons of Brazil, Dr. Luciano, Rinaldi, Natacha, Oliveira, two prominent people in the judiciary in Brazil. They are authors of books, so it's a great honor to have them here. I know people are still arriving because last night we had maybe too many cocktails, but the fact is that we also have the online event, so we can't just run late. And the theme today is something that is related to something that he didn't finish the phrase. I would like to thank ABPI, and on behalf of President Leonardo and also Peter Eduardo Sims, the Vice President. And the theme of this president is very timely because if we think about the theme of innovation, which is the great umbrella of this event, innovation requires investment. Investment for research, creation of intellectual assets, development of new ideas and tools, and the judiciary has an important role in this process because the judiciary provides agendas for society. It provides behaviors to be followed. And when it comes to AIP, we need to have previsibility and a possibility of foreseeing things, and we also want to have legal safety. And the legal safety in Brazil, legal security in Brazil fosters investment and equality, because with more investments we have better education, we have more incentives, and then we are able to evolve and grow. Okay, so I'm going to invite Natacha. Natacha, she has a seat at the Supreme Court of Rio. She's a master in law. She's a professor. She's the coordinator of the postgrad program at her university, the one that she works at. And I have no doubt that she has great decisions, very technical based decisions. She receives all the lawyers that look for her with a lot of generosity, and she's brilliant, and she brings great ideas to all of us. So, Dr. Natacha, the floor is yours. Good morning, everyone. I would like to thank Dr. Marcelo Mazzola for the invitation to be here and for the kind words in my introduction. And that is due to the friendship that we have and not exactly objective facts. And by the way, talking about objective facts, it seems to me that it would be relevant to bring here the issue related to the utilization of the judging of the, and that's it, and there's no specific technical criteria. And considering that we have the panel here, Dr. Marcelo Mazzola, who is one of the greatest specialists in IP and industrial property in Brazil, I could not simply not mention to the 360-degree test created by him that has been now, even though it began in 2014, but it's only now being discovered by the judiciary. And it is interesting to see how it changes the way that we judge things, because the judiciary is not supporting the judges that just make a decision based on what they think. They sometimes put themselves in the position of the consumer or of the end user. So if they think that it's not right, they basically judge violations based on their own opinions. So it's a very simple judgment. So this personal approach by judges is going to be replaced by objective criteria that were created and studied by Dr. Marcelo Mazzola, and that were utilized, unless I'm mistaken, for the first time in the Supreme Court in the judgment 1,726,000 process, which came from our Supreme Court in the state of Rio. And I thought it was really interesting because one day the directors of a company called JF Investimentos, that is the owner of the brand Neutrox, and that they have been making conditioners, hair conditioners, for a long, long time. Not everybody will remember because it's an old brand, but I remember in the 80s using that. It was basically a hair conditioner that was cheap, so it was a low middle class target product, and suddenly one of the directors think, what if we sue the other company, Dragão Química Indústria e Comércio, which is a competitor that had in the market, and they still have it, a hair conditioner also for people with lower income with the name of Natrix. So I think that I would not buy a hair conditioner called Natrix if I knew that the manufacturer was called Dragon. But that's not what is being discussed here. And the issue raised by the Supreme Court of Rio was the following. the packaging of both are very similar. So the competitor of Neutrox had a packaging that would be basically violating the rule because the packagings were very similar. So that is a violation when it comes to free competition. So the process was created. We had the assessment, which I believe to be crucial when it comes to industrial property. Even if you have objective criteria, as I mentioned previously, with a 360-degree test that was created. So the judge does not have the expertise to define these issues, to know what's similar, what is different. So I repeat, it is crucial that in a process where you're discussing violation of industrial property, that should go through a technical approach, and the technical test that is brilliant that was created by our colleague, as I mentioned before. So it was judged as the judge understood in the first round that there was a violation, as was from 2018. So we can't talk about irregular clientele capture or violation of market niches if these two brands have been living in the same market for so long together. And they added also the question of the segment. So even though both brands, Neutrox and Tetrax, are targeted to the same segment of consumers identified by the judge as a lower income target, the territorial influence of the two companies was very different. One had appeared in the state of São Paulo and then expanded to the rest of the country, and Tetrax was born in Rio and then created their expansion as well. And with the expansion, they kept their identities among their consumers. So the forensic analysis, the expert analysis, I'm sorry, identified that knowing that there were two brands, you basically only had to use one or the other because the price was similar and the product was similar. So then it goes to the Federal Supreme Court, and then there is an appeal trying to find a review of the accord of the Supreme Court of the state of Rio. And this is just a positioning, my positioning. This appeal was recognized. They had an accord reported by Minister Moura Ribeiro, and personally, because I like to debate processes, I have a lot of questions about the possibility of this case to have been known in the Supreme Court, but I'm not really sure it ended up there. So, but we are not here to talk about processes, because if I keep talking about it, I'll be here for the rest of the day. So the issue is that the appeal was recognized, but it was denied. And the argument was that the issue was not only based on facts, even though in the process there is mention to legal facts, but it's a merit accordant. But it is important in the sense that it establishes a precedent that is stronger than one that was not recognized. So when the process was judged, there's a reference to the utilization of the objective criteria that are included in the 360-degree test. Especially in this case, the issue of the two brands living together in the market, on the market. So the judges understood both from the court in Rio as well as the Supreme Court in Brasilia that regardless of the fact that the packagings are very similar. They were like a yellow tube with a red lid. The letters were also in red, and that, besides being something that they had been in the market together for a long time, it was prior to that discussion that they had been leaving. So both Neutrocas, when it was launched, as well as Statrix was launched, what they Bozano, which was Vela factory, that brought also a yellow packaging with details in red, and there were other competitors, not only JNS and Neutrox and Dragon and Tatrix, but all of them utilizing the same identity, a product that has a yellow packaging in the shape of a tube with the red lid. And they always lived in the same market. So in fact, what the Supreme Court understood is that this presence in the same market showed that they were able to keep their visual identity that they had without one invading the niche of the other. So in this case is a very interesting case, I believe. So it's something that was judged a long time ago, but it's being talked about. It was talked about last week, and I thought it was interesting to discuss this with you. Before this case, the Supreme Court in Brasilia, the Federal Supreme Court, with Minister Ansi Rodrigues, judged a special appeal where there's no mention to the 360-degree test specifically. However, she mentions objective criteria. So we don't use the 360-degree test, but she mentions objective criteria, and here the case was lingerie, which is a brand for lingerie, and they were thinking about the competition with Hope, which is another brand, thinking about basically panties and bras. So, and then the question is, what's gonna happen with this process? So it took place in São Paulo, not in Rio this time, and the whole debate was to know if the court in São Paulo would, so the court in São Paulo judged as it didn't make sense, saying that because you're talking about fashion products, there's always a trend in the market in the season, so they wouldn't have the right of the designs because of the trends, of course. So in the court in Rio, the accordion was capped, but the ministries made it very clear that it's not because the product comes from the fashion sector, that it doesn't have the right of protection. So there should be a protection about the design, even if the design is not registered. So as long as that is an element, an identification element of the brand, and in this case specifically, the appeal was denied because the identifying element was the utilization of lace and other characteristics. So that effectively, basically all panties and bras have. So what the assessment demonstrated was that what differentiated one brand from the other had not been copied, which was the letter M used by one of the brands, and the shape of identification with a little heart was present in both brands. But the Supreme Court in Brasilia, applying objective criteria, understood that they knew now the difference between what is objective and what is not objective when it comes to fashion factor, and it's very dear to me. The fashion sector is very dear to me because I have a son who is a stylist, who is a fashion designer. So it's not wearing pink, not because of the Barbie movie. The pink that I'm wearing, and I see other people wearing pink as well in the audience, that was launched by Valentino in the last season, in the spring-summer season. And I know that because my son was creating a collection, and when he saw that, he had used pink already with the intention to use something that he considered to be new. So Valentino launches that, and it's more valued than his, of course, because Valentino is more famous than my son. So fashion is definitely seasonal, which doesn't mean that it's elements that do not deserve protection. That was what the Supreme Court said differently. They thought there was no trade press violation because there was no copy of any differentiator. And the elements that were being pointed at as copied were functional elements, the utilization of lace, for example, which is definitely something that you see in panties and bras, generally speaking. That was the functional aspect of the clothing, as they mentioned. And if Luciano Rinaldi has some time to use the mic, I would like to hear from him. But I would like to share with you that I began talking about the need of using objective criteria so that we don't leave it up to the judge's judgment, basing the decisions only on how they feel about it. And for that, we have the 360-degree test. It's not the only one. There are others available, but it's recognized as the most complete one. And this lack of objective criteria made me think about it. I thought about it when I had to judge a process involving brands, and I had no idea of how I would start. So I looked for information's objective elements that I could provide. I didn't find any. And then that was judged based on what I thought, basically. And how do I have the guts to tell you that I judged something based on what I thought? Because parallel to that, we had another process going on that has a specialization that my court has not been able to implement yet, where the sentence, as well as the judgment of the appeal that has not reached the Supreme Court in Brasilia yet, was aligned with my decision. So what happened? Everyone who is from Rio, and those who are not from Rio as well, probably have heard that our bus station in Rio is known as Rodoviária Novo Rio. That's the name of the bus station. So if I had come here by bus, I would know what time I would be getting to the bus station. So everybody who lives in the state of Rio knows what that means. So they know where the bus station is. So a third company, not the company that administrates the bus terminal, which is a state concession, registered in the INPI for the utilization of the brand Novo Rio. And they registered that for many activities, among which 2 sites, novorio.com.br and rodoviarianovorio.com.br. So to sell tickets. And then they registered that in the INPI for basically the utilization of the brand Novo Rio. And then they have a process, they submit a process in the federal court asking for the denial, not denial, asking for the court to deny the use of the brand. So, and they said that the reason for that was that people who accessed that website were inducing people to a mistake. Because if I buy a ticket from a website that says novorio.com, not BR, I would definitely think that I am dealing directly with the bus terminal. And within the website design, there were many sentences saying, we're improving our services to better serve you, in a way that, at least that was how I construed it, they were making people think that they were dealing directly with the bus terminal called Novo Rio. And so we can't know for sure, but we can definitely believe that everybody thought they were dealing directly with the bus terminal. So if they had a problem, for example, with the purchase of one of the tickets, who would be sued would probably be the bus terminal. So in that sense, when I saw the process to analyze it, and it had been denied in the first level, and then I was thinking about objective criteria, and I didn't have objective criteria. So then I based my decision again based on what I thought. And it seemed to me that there was a damage to consumers. I decided to then proceed like so. The other ones that were being requested should not be granted. So in terms of the accord and the sentence, the judges mention the idea they mention is that there's a brand linked to a public asset, and that could not be registered by anybody else. So they went beyond that because they said that they were deciding who could use the name Novo Rio in anything that is identified with the transportation segment. So they decided that the bus terminal could use it because it is related to transportation. So when that was assessed and analyzed, I reached a conclusion, even though in this case my assessment was basically based on my instincts. And that keeps happening because the 360-degree test works well for certain brands' visual identity. But when it comes to domains of brands that have a name, we still need some objective elements. Here, in the case that I judged, it worked, but it could not have worked. And what I would like to make you think about is what are the objective criteria that when it comes to brands related to names, the academia and people who work with it all the time could bring as a contribution to the courts so that we have judgments that are less based on intuition and more based on objective standards that might be reproduced in most states in the country. Thank you. Thank you so much, Dr. Natacha. It's always great to hear what you have to say. And I think we actually have to think about when we're talking to... So now, I would like to invite Dr. Rinaldi, who is definitely one of the greatest references in the court of Rio. He is a judge that is courageous, and he bases his decisions like few judges do, that are always based on technical, scientific basis. He is a professor of civil processes. He has a book that was launched some years ago that is called Resources and New Incidents and Relevant Themes in the Court. It's an incredible book. And Dr. Rinaldi will also bring some decisions to make comments, some recent decisions to make some comments. He's going to mention Dr. Nunes, who is in the audience. So Dr. Rinaldi, the floor is yours. Thank you. Good morning, everyone. I hope everyone can hear me. I have to get used to using this translation device. Okay, it's great to be here with you. The auditorium is full, so I noticed that some people were a little bit late because some people had too many drinks last night. But I would like to say hello to the people that are here in person. It's great to be here after the pandemic. But I would also like to say hello to people that are following us online. I would like to thank ABPI on their president, Marcelo, and congratulate them for the success of this event in its 23rd edition, with a theme that is so important as the intellectual property is, which is much more charming than civil processes. Only weird people like us like civil processes that are impossible to understand. So there's no charm, which is the opposite of IP, which are delicious cases. Whether you win or not, you know that you're going to have a high level of discussion with the lawyers that deal with it. So they are generally a very high level of, and we know that, Dr. Natacha and I, because we've been dealing with this for a long time. I would like to congratulate Natacha, my dear friend, with whom I learn every day. One of the main judges, and I'm not saying that because of our friendship, but she's one of the main judges in our court. She guides people and judges, and we work together with other judges, and when she makes a comment, she is heard, and many times people follow what she says, so she's definitely a reference. Marcelo Mazzola, who is the leader of this panel, he's a brilliant lawyer. Everybody knows that he's a professor of civil processes. He's also an author of books, so it's a great honor to participate in this panel with you. So based on what people asked me to talk about, I've selected 3 decisions that I consider to be interesting for our debate today, among so many others that we could have chosen. And I'm not going to talk about hair conditioner because I'm bald, so I have no experience. I had hair in the past, but not anymore. It's a distant past. So I selected 3 cases. One, you will think that I wear panties, but I'm going to talk about panties, which is something that she mentioned a little bit about already. But it was a suggestion from Natacha. The second one is Lobutin. Dr. Marcelo Nunes is here, and if you allow me to speak a little bit about the case, because she was the judge, she's a brilliant judge. She's a brilliant judge, and she made a brilliant decision about this theme last week. And a case that I judged that I love, which is Harley Davidson against the bar heavy duty in Praça da Bandeira in the city of Rio de Janeiro. So that's going to be my 3rd case. So you might be asking yourselves, you as judges, what goes through the minds of a judge when they have a process, a lawsuit involving IP? So what's the driver? So first of all, you see that you generally have good lawyers. So you have to hear both sides, and then you have to think about precedents within the idea that you have to keep the jurisprudence that has to be coherent. And the Supreme Court in Brasilia has a great rule because they have previous cases for us to use as a reference. So now we have to think about Article 170 from our Constitution that has the main principles of economic activity, which is the right to free competition and also free market and protection of brands and IP that is also present in the Constitution. So my point is, we have to see, was there unfair competition? And that is something difficult to establish right away, unless there is a very clear case that you don't even need an expert. You look at it and you see like a Louis Vuitton bag, and you see another one that is exactly a copy of the other. But not always it appears. Of course, there's piracy, but sometimes there are subtle cases with few mechanisms to induce consumers and try to fool them and then have somebody else's clientele. And doing that is not illegal. If you want to get somebody else's clientele, that's part of the market. A competitor wants to get somebody else's consumer. But there are legal ways and illegal ways of doing it. So what we have to observe is if there was fraud or a dishonest action to conquer clientele from somebody else. So was there, for example, the idea of inducing the consumer to a mistake? Did the consumer buy something thinking they were buying something else? What about the advertisements? So did the advertisements, for example, copy the success of somebody else's advertisement? So basically, are they just following the school of fish? That's an analogy. So they basically don't do anything but just copy what's been done by somebody else with years of research. And then they suddenly want to use those ideas, just basically copying what other people did. So the unfair competition can happen, just like I said, like with the Louis Vuitton bag, which is equal, or when you use somebody else's, another brand symbol, like Harley Davidson. And we have to see, again, as I said, if there's like false statements about the competition, that is seen in Article 195 of the Law of Intellectual Property. So they list all the hypotheses of unfair competition. We also talked about, as I mentioned before, using somebody else's success and also using somebody else's brand in a way that shouldn't be done. And I'm going to talk about this briefly. So when the judge is going to think about the criteria, it seems to me like they have to have in mind in any process not to make decisions based on what they think. When I was much younger, I studied economics in an American high school before I studied law, and I learned something with one of my teachers that was talking about what he called the invisible hand. The market regulates itself. But I see somebody in the audience saying it's not like that. No, I know, I understand that. But I'm just telling you what an economist told me, and I'm not an economist. I'm just repeating what I heard. But so there is a certain space where the market ends up adjusting itself. You mentioned that the brands have been living in the same market for many years, and the Supreme Court said, yes, it is similar, but the consumers understand who is who.
It's the market. The market will fix itself. Someone might lose money, but it's important that once you identify what went wrong, the judicial might work in order to protect the brand holder and the consumer, so you don't buy a product thinking it's someone else, and then you have a loss further ahead, and whoever created that might have loss because he didn't have the revenue. There were losses. So the indemnity not always will fulfill the loss, compensate the loss. So there is importance of the precedent and of being things being foreseeable and having legal security. And she mentioned the personal impressions of the judge. In those cases of intellectual property, there's room because you need to examine, and each of us has an impression. So there were So you make an examination of that, and everybody has an understanding. There are several, and I've examined, and the expert said, forensics had an opinion. I missed a technical opinion, like this model here is exactly the same within that model, so that's technical. So you have to take a look at both sides, it might seem. So that is why not always the judge follows the conclusion of the forensic opinion, and sometimes we miss technical information, and sometimes the consumer might be confused with the two brands, same products with the same purpose. So many, how many already did that? So now I'll tell you about the Hope case, about recent sponsored links on the internet. So you buy a product from Hope, and then you go to Mercado Livre, any site on research, and the sponsored link, what does it do? You want to make use of the Hope brand, who sells underwear, female underwear, and then you have a brand that makes female underwear, and the moment they make the ad, they put a hashtag or a sponsored link using the word Hope. Why? Because Hope is a famous brand, and women will look for Hope quite frequently. So let's have a free ride here. So then you go there, you may make the search, and then you put on top of the list female underwear, and you find Hope underwear. And in the digital medium, you don't have contact with the product. And when it arrives home, you see that sometimes you don't even see that it's not from the same brand. To forbid loss and deviation of consumers and avoiding consumer confusion. So we decide very much based on that. And it says it's not illegal to capture someone else's clients, but not by means of fraud. It was understood that there was a parasitic competition, and related the confusion was understood that we needed to see the perspective of the average citizen. So it doesn't have to be someone specialized. So a man who will buy, let's say, lingerie for his daughter, he can see what brand it is. So he can identify. The decision differs from the specific search from the generic brand. Let's say I want to buy lingerie. Let's say you can put a sponsored link, you have it there, because it's random. But in case it is specific, the court understood that this use of the keyword with the name of the competitor is illegal. And they expressed the accentuated vulnerability of consumer in the digital environment, which is a reality. And it also showed that you must have at least a possibility of there being confusion and now the evidence of there having been harm. So I consider that an important decision because it is about commercial, digital commerce, and a parameter was defined regarding these ads in an environment of growing strengthening of digital commerce. And an isolated case, which is that of Louboutin, the sole of the Louboutin shoes, which is red. I know it from hearsay because when I saw the price, I said, well, forget it, I'll save it for later. But those who see the red sole, and they know it is Louboutin, it's an international, it's a French brand, internationally known. But no other company can make a female shoe sole with the red color. Louboutin tried to look for the registration of the protection brand in the year 2009 at the time, and it was not possible to make the registration, and there was not this so, and that had a Louboutin hashtag, and the court said, in spite of there not being but the court said in São Paulo understood that in spite of there not being the register at the NNPI, there was a violation in terms of making use of someone else's success, leading the consumer to a mistake. And they'd had the Louboutin hashtag on the ad, and the consumer to a mistake. And they'd had the Louboutin hashtag on the ad, and there wasn't even an agreement between Louboutin and Bruno Silvio's shoes. And she said, she admitted she breached the agreement. But in parallel, last week, the 13th court granted suspensive effect over the request from Louboutin, and this not granting this decision that protects the brand, protects and the competitor might think that any company now can use the red sole. The longer we have this lack of definition, there will be a loss for several people who will buy that, perhaps taking the wrong product or sometimes aware of it because they can't afford the original one until this registration issue is solved. So the decision I congratulate the judge for that and expresses the favorable Louboutin registration in several countries. So the point is, how does this behave in the world? And why won't Brazil behave the same? So we have a standard which is not only national. We need to see how the world addresses this. And there's also the decision that for protecting the brand, the court in São Paulo understood that it is not necessary to have a full copy of the product for there to be an undue reproduction. You can have a violation without the perfect plagiarism based on certain traits that might lead the consumer to a wrong choice. And I'd like to comment here a situation I went through. Let's say I'm a Coca-Cola drinker, a heavy one. And once I went to the market and I bought 18 Coca-Cola zero-calorie cans, and I arrived home, and then it was Guaraná. It was the wrong soda. So right by Coca-Cola, there was a black can of Guaraná, which was similar. So they had a free ride on Coca-Cola's success, and that happened to the Brahma beer and the Itaipava beer, the Petropolis from the Itaipava beer, which has this red can as well. And so on and so forth. I'd like to finish with the last case here, the sad case of Harley Davidson and Zeca Urubu. Zeca Urubu was the guy who owned a bar on Ceará Street of motorcycle riders, and he was proud of selling the worst beer in the world, and it was a humble place. And he would sell sandwiches, hamburgers, and there was rock music, and the bikers would go there, and they had a shield which was in the format of the Harley-Davidson shield, but within it said had a heavy-duty beer bar. It was inspired, so to say, a tribute being paid to Harley-Davidson. But it was Zeca Urubu's bar, and Harley-Davidson carried out a lawsuit saying he was breaching the brand law by using the Harley-Davidson logo. The first court judge granted indemnity, but there was an appeal, and we understood that Zeko Urubu was right. Come on, there was no loss for Harley Davidson whatsoever, no loss of clientele, no parasitic competition. No one was led to a mistake. Leave Zakarubu and his beer alone, the worst beer in the world. This case went to the Court of Appeals, and the Court of Appeals understood it differently otherwise. And it is a matter of perception, after all, of that brand. So what did the Court of Appeals up there understand? It was, they said that the guardianship of the brand considers the single possibility of confusion, and that not confusion itself, and that brands have to be evaluated according to their similarities and not differences, and compared according to the set and now details. And the court says that the holder of the right can want to see his brand associated to any of the other product or service. And so the court then sentenced the bar to not use the brand, and now they're paying for this indemnity. So the reflection I make here is the following. The Harley-Davidson brand, could it be that the Zakarubu bar want to do something like that? Could it be that Zakarubu knew that there is intellectual property itself, when perhaps he thought it was a tribute because he loves Harley-Davidson? The fact is that at given moments we need to be somehow human as well. I think Zakarubu should not be sued by Harley-Davidson to pay 30,000 real, which he doesn't have. We need to put our feet on the ground. We need to know who is really harming someone else with this intention, on purpose. Was there any ill faith? That is what I consider when I have to judge. Or is it something, a market issue, that could be tolerated by the market? We had a debate. I had a debate with Marcelo on this, but it is a matter of point of view. He's not right. I'm not right either. He's not wrong. I'm not wrong either. So, this looks like that, and it stole their clientele, their customers. Well, it was not so. I think we need to have certain sensitivity when it comes to this, to see who really is acting in ill faith, perhaps different from those who made a mistake, but with no ill faith. So, and about to finish, that was not the case of Benjamin Button, but of Zakarubu. Thank you very much for your attention.
Eduardo Rinaldi, muito bom.
Eduardo Rinaldi, very good. It's always good to hear your talk about these incredible cases, and it's always interesting to hear about the other side. How, when you receive a lawsuit, what do you evaluate, your perception, your feeling, even for us who are lawyers, a majority of us, to understand how the case is presented, what can be relevant in terms of the image, in terms of evidence. You mentioned market research, the importance of there being market research in certain cases. So, what called attention about this Louboutin case, besides the decision itself, was the last paragraph of her decision. And we like this theme about judicial cooperation. Dr. Márcia, she calls the judge in São Paulo and asks him, and he would like to give their sentence or opinion. Thank you very much. Thank you very much. Well, thank you for this excellent panel, and I'll be quick about the capacity to foreseeability. There are two questions. First of all, the need for forensics, sometimes we think, what is the profile of this professional? So what do you understand as the best professional profile to conduct such forensic work? And regarding what Marcelo asked, the weight of a market research in trade dress litigation, in your opinion, should there be a market, could a market research replace forensic work, or should it be included? And for that reason, and that's the importance of professionals' profile. Well, regarding the naming the professional, it must be someone experienced in the area, a professor, intellectual property professor, an intellectual property attorney, someone who might be experienced in, who might provide elements, and someone who might have worked on the brand, someone from the automobile industry who might add something to it, or someone from the pharmaceutical industry. In the case of a laboratory, you can't have more than one forensic. So that would be the profile, depending on the matter being discussed, but someone duly experienced. So, and you can call an amicus curiae also. Amicus curiae can also be a legal expert, someone who would provide an opinion chosen by the judge. I'd like to hear in this case, let's say, Dr. Marcelo Mazzola as amicus curiae, and he doesn't have any interest in the cause, in the case. He's not my client. I have no interest. So how does it work out abroad, for example? It is not evidence. It is an input to the process. And regarding the second question related to market research, it has to be brought by one of the parties, and the other party may carry out their research as well. I think it wouldn't be the case for a forensic to carry out market research, and you may hire a reliable research institute. So it has to be reliable. May I disagree? Okay, no problem. In this case, regarding the first case, I fully agree. As for market research, I allow myself to say that as it is very relevant for the trial, it was one of the decisive factors in this lawsuit between this Tradex. One of the elements brought by the forensic did not make carry out market research, but he went out to look for these elements to see if the consumer was really buying the wrong product, Neutrox instead of Neutrex. I think that considering the relevance of are they similar? And he will mention the are they similar? And he will mention the differences, the similarities. And this one is the same model manufactured elsewhere, but with a difference in the color. And he can make an identification that the layman will not be able to. So let's say, if you look at this is somehow similar. So as far as I see, as far as I understand, it is not a technical forensic work, but an opinion forensic work. So as I learned that we should never interrupt a judge of a court of appeals, justice, I think you're both right. So I declare finished, concluded this panel. Thank you very much.